years ago this year in 1971 by women who were influencers in their communities and in politics. They had a vision that we needed to increase women's political participation, including recruiting and training women to run for office. In Virginia, we are here to carry forward with that mission and do much more, including being on the front lines of changing legislation. In tonight's VLAW conversation, we will discuss combating virtual sexual harassment in Virginia, focusing on the history of the legislation on this issue. So I'm honored to introduce our esteemed panelists tonight, and our conversation will be moderated by Tanja Roberts, JD, who is mother of 3 and also the NWPCVA Vice President of Policy. Our first panelist is Kelly Fowler, who is dedicated to the service of others. A resident of Virginia Beach since childhood, she's a small business owner who specializes in military family relocation, a former school teacher, and a state delegate who works for results that matter for us. Since she was elected to serve, she was a key vote to expand Medicaid, helping connect more Virginians with affordable health care. She led the effort to decriminalize marijuana in Virginia, and she voted to raise teacher pay and provide tax breaks for small businesses across the Commonwealth. A mother of 3, Delegate Fowler is aware that the choices the Virginia legislature makes matter to the next generation. It's why she's committed to taking bold action to curb gun violence, fight flooding and the climate crisis, implement common sense justice and policing reforms, and build a more equitable economy for all. So thank you, Delegate Fowler, for joining us. Senator Scott Surovell represents parts of Fairfax, Prince William, and Stafford counties since 2015. He is the vice chair of the Democratic Caucus. Prior to his time in the Senate, Surovell served 6 years in the House of Delegates. Surovell lives in Mount Vernon area of Fairfax County with his wife and 4 children. He maintains an active law practice. He has dedicated his legislative career to fighting for Northern Virginia's fair share, protecting consumers, and preserving our environment for future generations. Thank you, Senator Surovell. K. Scott Miles serves as the Deputy Attorney General for the Criminal Justice and Public Safety Division. Prior to his appointment in December of 2020, he served in the Capitol Defender's Office for Central Virginia, the Chesterfield Commonwealth's Attorney's Office, Private Practice, the Richmond Commonwealth's Attorney's Office, the Richmond Public Defender's Office, Piedmont Legal Services, and the Charlottesville-Albemarle Legal Aid Society. He earned his BA in philosophy from the College of William and Mary and his JD from the University of Virginia School of Law. So thank you for joining us, Scott Miles. So now I'll turn it over to Tanja Roberts.
Hi, everyone, and thank you so much for being here for this amazing topic and being game changers and waymakers. So I want to just pivot a little bit over to a reminder of where we were last week, how we introduced this topic initially to the community. And we're going to show a clip from one of our guests' interviews last week, Ms. Katina.
Coming back in. This is just as bad. There's nothing any different in this and unwanted touching or unwanted comments. It is 100% harassment. If it's unwanted, it really doesn't matter to me what the act was. It's a violation. And it upset my entire, not just my entire day, it upset me emotionally for a while.
And, you know, just as a reminder, there is a law that protects individuals under the age of 18 from virtual sexual harassment. But once you turn 18, there's nothing in place. So I want to welcome Delegate Convirs-Fowler. Did I pronounce it right? Yay.
Yes, ma'am.
Thank you. Thank you so much for being here. And wanted to just ask a couple of questions of you as kind of a summary of the bill that you introduced last session, which was House Bill 2254. Could you give us just a bit of why you introduced that bill and a summary of what it's about?
Absolutely. Thank you for this opportunity and setting this up. This is amazing. And it's great to have this opportunity to talk to the public about this bill. Virtual harassment has been going on since we have been able to get things virtually and receive things, especially in real estate. And I used to be a school teacher, and now I am in real estate, and I have a brokerage firm. And one thing that about agents that's unique is our numbers are out there. They're out there everywhere because we need to be able to be reached a majority of the time. So our cell phones are always with us, always in our hands or in our lap or close by. And what was happening was I had constituents and I had people in the community, in the real estate community, reach out and say, this is happening. What can we do about this? I've gone to the police. They say there's nothing they can do. We've tried this route. We've tried talking to an attorney, and there really is like a hole in the law for this. And just it's outrageous to get a picture that's unsolicited and inappropriate. I think what we ended up calling them is inappropriate unsolicited pictures is just the quickest way to be able to explain it to someone. And I think about my daughters and how common airdropping is. One time somebody sent an airdrop and they showed me the phone, my 12-year-old, and was like, what is this? And it wasn't a picture of anything. It was, do you accept this? And I think a lot of the times the kids may not know not to accept certain things and they might be fooled. So the thought of that happening really weighed on me and thought we need to do something about this. So of course, being in the legislature, it was a little easier to get going and get this started. And I thought it would be a little easier. I thought everyone was on board. It did pass out of the House 100% unanimous, which was amazing. So, but I'll save that story for later, but that's why the bill was put in originally.
You can certainly start there. You know, how was it received in the House of Delegates? What was the reception? How did other delegates view that bill that was introduced?
Well, it goes to the subcommittee for, courts and justice. I'm not on that committee. It's a very, very technical with law. There's a lot of attorneys on that committee, and they really worked on this bill for a while to get it right. Everybody was behind the intent that it was bipartisan, but we realized that it's very tricky. It's a very tricky code section because it's been put in place kind of patchwork as we needed things when it came to, there's a section about revenge porn. That is a whole section that got added. And so it kind of was an issue. It was an issue about where it would fit. So we had different drafts made up, and trying to get those minds on it is what we were doing. We were getting the attorneys to look at it with us. And so we ended up having to edit it several times. So, but everybody was on board with the intent. And then when we got the language right and the Courts of Justice Committee, they felt like it was right, we sent it to the floor and it passed unanimously.
Mm-hmm. So, you know, and you mentioned that you're being in the real estate industry and how your numbers out there for everyone to see. That was the same story with Katina. You know, she's a realtor as well. And but to have the added part of her daughters being present, and, you know, they actually saw what this was, because it shocked her, you know. And so I think a lot of times maybe people are kind of numb to how those unsolicited inappropriate pictures can affect you, you know.
I heard something the other day that was really helpful in explaining it. Somebody said that if somebody was in an alley and they just showed you their knife, you would be scared of them because they would have that power, and you would be scared that they were going to use that and do something to you. I think that might help a lot of men understand the magnitude of that, because when you're getting flashed or cyber flashed, it is a scary moment to realize that person is just looking at you. They know that they can violate you. Right.
Yeah. And it's not something that is that's welcome from strangers, certainly. And it's not something that is an act of like a compliment or of endearment, you know.
It doesn't compare to, somebody tried to compare it to women flashing, and that is a different thing. You don't see men doing that. It's just how our culture treats men and women, and it's not okay either way, but it's treated differently. And I guess that's what the comment is on, is how it's treated differently. So some people do try and argue, well, I mean, I would welcome if a woman did that to me. I've heard that argument. And it's like, well, and then you go back to that. I think that knife one really explains it pretty well. If you saw somebody in an alley with a knife and they just showed you, you would be scared. So that helped my husband understand it quite a bit too.
Right. Well, thank you. Thank you so much for answering those questions. I want to go over to Senator Surovell, and I'm trying not to let my Southern drawl get in there to elongate your last name, but thank you so much, Senator, for being here. And wanted to inquire of you, when the Senate reviewed Delegate Convirs-Fowler's legislation, can you give us kind of a summary, a little background of what happened, what the discussion may have been around that?
Sure. Can you hear me okay?
Yes, I can.
Okay. Yeah, sorry, I'm in my car between events right now. So glad the technology is able to facilitate this. So, first of all, let me just tell you partly where I came to this issue from. I've introduced legislation 2 or 3 times now to actually decriminalize sex, or actually not decriminalize, but defelonize sexting between minors. I've been dealing with this issue now for about 4 or 5 years, because if 2 consenting, I say consenting, not unsolicited, but consenting children send pictures back and forth to each other, it's a felony. And a lot of kids not having sort of fully developed brains, or frontal lobes, but having fully developed the rest of their brains that work, including the parts that get us excited about certain activities, cause children to do some really stupid stuff. And as part of that legislation, I learned a lot about sort of the human motivations behind what causes all that, the way boys and girls process that differently, and I tried to make it so that children couldn't be felonized as child pornography manufacturers for doing this type of activity. And one of the things that obviously I was aware of doing that is that if 2 adults send pictures back and forth, it's completely legal. If you as an adult want to send a picture of yourself to somebody, it's legal. If somebody sends you a picture of yourself, it's legal under Virginia law, if that's something you want to do. And there's a lot of different reasons behind that, including some constitutional First Amendment reasons. But I think the policy decision underlying all this really changes a lot when you're talking about pictures that are unsolicited. That is, a picture where either people don't have any kind of a prior relationship of any kind whatsoever, and this just comes out of the blue, or where perhaps you don't have an amorous relationship, you're not dating someone, or you're not have a sexual relationship with them. To get a picture like that, it can be very disturbing and cause a lot of consternation and worse. And so first of all, I think it's important that we talk about unsolicited pictures. And a lot of the conversation, I felt like I didn't go back and watch the video. I mean, the meeting is there for everybody to watch if you want to watch it. It was all videoed, but my recollection is that the sort of the issues that came up were twofold. One was, I believe it was our counsel. We have a couple different lawyers who are in there in the room. The committee hires an independent counsel, and then we also have somebody from the Division of Legislative Services. And there was concern that the bill might implicate some constitutional First Amendment issues. The government can only regulate speech in certain ways. And in order for you to regulate all, certain speech, you have to show that it causes some sort of harm before it becomes constitutionally able to regulate. That was one set of issues. And then a second set of issues was that a concern about sort of false positives, about how you would ever go about proving this, and the possibility that somebody could be, charged unfairly. Like one of the scenarios that I was concerned about is that, I've as a criminal defense lawyer, I see, I see scenarios arise post-relationship a lot, where some people, their relationship will go down in flames, and eventually post-relationship some criminal charges might arise. And if there are pictures like this in somebody's phone, there could be a dispute about sort of when the picture was sent, whether it was wanted or unwanted, and the ability to prove or disprove that might be solely based on somebody's word, as opposed to some clear moment that you have in writing that can show sort of when the person stopped wanting to get those kinds of pictures, right? And there might have been a history where people were sending back and forth in their relationship, and then they broke up, and and there could be a situation where somebody could use it to leverage a criminal charge out of somebody. And so that was one of the issues that I was worried about as an attorney, and seeing some of the scenarios that I've seen unfold. So that was some of the stuff that went on. Kelly or Delegate Fowler might remember some other things that were said or whatever, might trigger some more memories in my mind, but that was my recollection of some of the focus of the meeting. And it's clearly a problem. I mean, I think only one other state now has passed this. I want to say it's Texas, and there's been some litigation about it. And I've been talking to some people to figure out if there's ways we can get around the constitutional issues on it. And because, and by the way, I grew up, I mean, luckily when I started dating, cell phones didn't exist. I can't imagine why people would send naked pictures of each other to each other as part of a dating thing, but I guess that's a thing now. I mean, so it's a hard thing for me to appreciate that anybody would just want to do voluntarily, but it's, it clearly causes a lot of emotional distress if you get something like that out of the blue and it's not something you want.
Mm-hmm. But I think one of the questions that I had was about the harm. You said with it being possibly a constitutional concern and not being able to prove harm. But is that because perhaps a majority of men might be evaluating what harm is in a situation like that, and maybe they can't really understand the harm, say to a woman? I mean, the solicitation, the unsolicited pictures, of course, could be, a woman sending something to a man, or, it goes both ways. But what is the harm piece?
Sure. Well, first of all, I don't think what I said was that it's hard, that you have to show the harm. Or I think what I said was that before the government is allowed to regulate certain kinds of speech, the government needs to make a showing that there's some kind of harm associated with the speech. I wasn't saying it has to be proven as part of a specific case or anything. I'm just saying that in general, the government can't regulate speech until you can show that speech creates a dangerous situation or some harm or something. But to your point, I don't think there's any question about that. I mean, I just finished reading a book, which came out about 4 or 5 months ago called Men Behaving Badly. And it's all about the sort of evolutionary genetic roots of sexual conflict between human beings. And it talks a lot about how men and women are just wired completely differently when it comes to sexual issues, when it comes to sort of dating and how to date, or how to, whether you want sex or who you want to have sex with. And, there's long evolutionary reasons as to why we are wired differently. And there's lots of research that shows that men have just completely different ideas about sort of short-term sexual relationships, or sex with people they don't even know very well, or about having sex with multiple people, as opposed to women who not always, but tend to be a lot more selective and careful, because, getting pregnant is a much bigger investment for women than it is for men, right? And so just from an evolutionary basis, men and women approach these issues very differently. And one of the points in this book I was reading is that the law frequently frames lots of our legal standards in terms of a reasonable person standard. Whereas in an employment context, when you're talking about sexual harassment, an advance by a man towards a woman is often viewed very differently than an advance from a woman towards a man by the recipient. And that, using a reasonable person standard might be the wrong standard. Maybe it should be a reasonable woman standard and a reasonable man standard instead of a reasonable person standard, because men and women are not the same. And so, these are things that I think I think in large part haven't thought about very carefully in terms of how we craft our laws over time. And after I read this book, I was like, that gives me a lot to think about. And, this issue is one of those issues, I think, where those types of differences really play themselves out.
I agree. I think also men's perception of what is courting maybe, or what is amorous, might not be, is not always the same, especially if you think that sending that picture shows that I am interested in a quality relationship.
Just listen, it's never occurred to me to do that, to try to, well, of course, when I was dating before I got married, I didn't have a phone, so it wasn't really an alternative, but I never really thought that was a way to get a date either or anything. I mean, I guess Louis C.K. was doing that, and he, ended up, and Harvey Weinstein, I guess the two of them, from what I've read, were involved in that kind of activity, at least in a face-to-face basis, not by phone. But, I read another book called Chimpanzee Politics, which actually Newt Gingrich recommended that all of his, everybody in the Republican caucus read. And that book was a study of a 2-year study of a chimpanzee colony. And one of the fascinating things I noticed in that book, which I was reading about a year ago, was that that's the way young male chimps used to try to court some of the women chimps in the colony.
Mhm.
And it made me wonder sort of, whether this is, part of some young men's evolutionary wiring that they, still today aren't able to suppress that very well. And that's what caused it to come out. But in any event, there's a lot of underlying psychology behind all this, and that's, I think, men and women approach these issues very differently.
I think it's a lot of grooming. I think it's a lot of grooming and testing to see what they can get away with. And once it's done one time and it's not, they know they can do it more, and they know there's going to be no consequence. And
it becomes a standard almost, right? Like it becomes a new standard.
Yeah. And it's very, when you think about flashing, or when you think about, children that are sexually abused, and you think about those situations, that is what is going on. They're testing the limits, I guess, the boundaries, right? And in adults are doing it as well. That woman didn't get too upset. I can keep talking. I can maybe push it. Maybe I could get further with it. So I think there's a lot of that's going on.
I agree. That's probably the case. Well, thank you both for that input. And I want to welcome Mr. Scott Miles to the screen and to the highlighted seat.
Good evening.
There you are. Thank you for being here.
It's my pleasure.
I wanted to inquire, we heard how it went in the General Assembly. So we heard about the reservations that some senators may have had. And we want to know what your thoughts might be on the whole ball of wax here.
Well, let me not bury the lead. The Attorney General supports this effort. And so, we want to work with Delegate Convirs-Fowler's and see if we can get something on the books that'll be useful. I did review the video from the Senate Judiciary Committee hearing, and I was puzzled at first because I was looking at the delegate's bill as it passed the House, and the concerns that the senators seemed to have didn't line up with the text that I was reading. And then I realized there was a substitute that had been introduced in the Senate. When I look at the delegate's bill, I don't think it suffered from the defects that the senators were concerned about. Our office looked at that bill as we review every bill that's introduced every session. And we were not concerned about the defects complained about, at least in the introduced bill. I do have one thing to bring up, and that is something that Senator Surovell referred to, and that is the effect on juveniles. So we're always trying to avoid situations in which we push kids into the deeper end of the criminal justice pool if we can. And I noticed that the bill was amended in the House to apply only to adult victims in recognition of the fact that we have other provisions that we can use to prosecute people who target children. But we're going to ask respectfully the patron consider including a provision easily included that would exempt children from prosecution under this bill. And that's really in recognition of the fact that it's would establish a class 1 misdemeanor. It's a jailable offense. And that has a host of other consequences for children, including potentially pre-trial detention in a detention home. Post-adjudication can also trigger commitment to the Department of Juvenile Justice, assuming the child has certain predicates earlier in their history. So, we think it's a valuable piece of legislation. We want to get behind it. We are going to make that ask that we make it prosecutable against adults who are targeting adults. And, to one of the delegates' points, we can talk about how men have evolved and women have evolved, but part of the value of laws is to provide those boundaries, right? And if we're going to educate men to not engage in this sort of harmful behavior, it's really helpful to have a law in the books that can be enforced, and that sends a message that it's not appropriate to do. So,
well, you mentioned having that provision in there to protect minors, but how would that provision be implemented? Say if someone who is a minor number wise, but they are maybe have another charge on them, and they, the prosecutor has decided to try them as an adult. How would that work then? Had you given any thought to that piece?
So, this as a standalone wouldn't be eligible for trial as an adult. Class 1 misdemeanor wouldn't make a child eligible to be tried as an adult, regardless of their age.
But if they had other charges, and that was one of them, how
Could it be
is
an
that?
ancillary charge to another charge that was eligible? Yeah, I mean, that's an issue that could come up from time to time, although it's there would be another charge that'd be sort of driving that process. What we'd like to avoid is having this charge be something that would potentially trigger a commitment to the state or detention in a detention home.
Very good. Thank you. Well, do you have any additional concerns other than the minors or trying children? Do you have any additional concerns with regard to virtual harassment? Are there any other little areas that maybe kind of give you pause?
Well, I think this is an encouraging note. When I was preparing for this, I came across a Court of Appeals of Virginia case, and it was interpreting our indecent liberty statute. And that's a statute that is particular to things adults do targeting children. And one of the provisions in that statute is for exposure, flashing, adults flashing children. It doesn't make any mention of computers or cell phones or digital pictures or anything, but the Court of Appeals, this is the Hillman case from 2018, was interpreting a conviction under that statute for this behavior. It was an adult who had sent a photo of her Snapchat to a 14-year-old. And our Court of Appeals said that indecent liberty statute covers cyber flashing. They didn't use that term, but this behavior, which tells me a couple of things. First, I think we have a receptive audience in our Court of Appeals, even before it was expanded for this kind of legislation. Another thing is, if we had creative prosecutors, they could probably prosecute this behavior under our indecent exposure statute if they wanted to. I understand the value of this law makes it absolutely clear that it's a crime, and we're not relying on local prosecutors' discretion. But I think if the same analysis should apply to the indecent exposure statute that applies to the indecent liberty statute. So I'm encouraged by that particular opinion, and I think it's always worthwhile to make sure that whatever laws we pass will stand up to appellate scrutiny and constitutional challenge. But we don't see that the law as introduced and as passed in the House as being vulnerable.
Well, I think that's a great, focus point on dealing with the indecent liberty statute. It seems almost that, could that be even amended to add a section to that? Would it be received better, or would it be welcomed more if it was just, say, in addition to the statute that's already in place for indecent liberties?
Well, there are lots of different ways to draft a provision, and having a standalone code section, as Delegate Fowler's bill, at least the amended version in the House, would do, I think accomplishes the goal. We could also accomplish it by amending statutes that are on the book. So the indecent exposure statute, we could amend so that it explicitly covers cyber flashing, if that's the way we want it to go. And that would be, I think often it is helpful to disturb the existing code as little as possible. That sort of adds to the comfort level of the people you're asking to endorse it, and also to the courts you're asking to interpret it.
Mhm.
So we don't have a position on whether one would be better than the other in this particular effort. I think either one is possible.
Okay. And how else can we ensure that we protect women over the age of 18 from virtual harassment?
I'm going to go back to that education piece. You know, the law functions in a way that is aspirational as well as enforcement, right? And so if we're trying, we have this new environment in which so many productive things are accomplished remotely, like this meeting, for instance, right? But unfortunately, people who are willing to prey on others also can use the same tools. And so the law has to evolve as the technology does. So, you know, how do we protect women from this sort of newer threat? A lot of it is educating, and really we're talking about educating men, young men, about what is appropriate, what's not appropriate, and what has consequences with it as a behavior, if that's persuasive to them. And to get there, I think a law is helpful, and then educating the people who enforce the law is helpful. So our local Commonwealth attorneys, our police officers, you know, as in the normal course of things, they educate each other on changes in the law, but I don't think that we would leave it there. I think that everybody who supports this sort of measure would be amplifying that message to get it out to the law enforcement community and then to the larger community. It really is about making it clear to men, and I think we're mostly talking about young men who do this kind of thing, but maybe that's an assumption I should make, that it's not appropriate and the law will punish it.
Can I just say though, I mean, first of all, I think the indecent liberty statute only would apply to children victims, and it wouldn't apply to adult situations. And so, and if we're talking about a child who's sending it, you know, the child pornography statute already picks that up anyway. And so all we're talking about is a piling on at that point. So the indecent liberty situation would only deal with an adult sending something to a child. So that in terms of a solution, just keep that in mind. Secondly, on the indecent exposure statute, I think there's it's not clear in the law as to exactly what constitutes indecent exposure. I have seen cases where people have been naked in public, and there's been a serious question as to whether or not that's actually criminal activity or not, depending on the exact circumstances of how they present themselves. I'll just put it that way. So it's not always clear what is an indecent exposure versus another. I mean, obviously, if somebody, you know, walking around in a trench coat and you know, open themselves up to somebody while aroused gets you to home plate. But things that are short of that don't always get you there on the criminal side of things. And which brings me back to, you know, often when we have problems, people see the criminal system as like one of the places to try to resolve them, when in fact, it's often a lot easier to fashion remedies on the civil side of the court, because there are a lot fewer constitutional restrictions and the burden of proof is much lower, and you don't have to worry about Fifth Amendment issues and a lot of other things in terms of trying to prove things. And so, for example, on revenge porn, I know the first time we passed that statute, it was Delegate Simon wanted to make it a felony, but we ended up making it a misdemeanor, which I thought was a big mistake, because most Commonwealth attorneys will not extradite somebody over a misdemeanor. And this is a misdemeanor, right? I mean, and the problem is when you get into felonies, your fiscal impacts get a lot higher, and it gets a lot harder to get something through the legislature, both because of the stigma of felonization, but it also costs a lot more in our budget to set aside the jail beds for these things. But if you're looking for a criminal remedy that works, often if it's going to cross state lines, like electronic crimes do, you know, it's not really particularly effective if it's a misdemeanor crime. And then, but you know, if you get to felony, then it just gets harder to do. But you have to deal with constitutional problems. You have to deal with the burden of proof. You have to deal with search and seizure. You have to get the government to investigate it. But if you have a civil, if you create a civil cause of action, for example, for something like that, then the victim has a lot more control over A, bringing the lawsuit, B, conducting discovery, sending out subpoenas, you know, controlling their destiny, as opposed to convincing some Commonwealth attorney, who, by the way, is usually a male, that this is something that ought to be prosecuted, right? So I would just, you know, point out though that you know, I mean, that we eventually, by the way, we also did pass a civil statute later about revenge porn. I believe it was now Congressman Wexton's bill that created a civil cause of action with damages and for revenge porn. Before, I think your only remedy was a copyright remedy or something like that. If you sent a picture of yourself to somebody and then they spread it around. But so that's something that's also out there, is on the civil side of the court, that I think is often neglected because people, you know, want to try to criminalize a lot of things as opposed to recover civil damages. And absent a statute, by the way, it's very hard to bring a civil cause of action for this, because in Virginia, you typically cannot recover pain and suffering damages absent a physical injury. So unless somebody actually touches your person, you typically can't get pain and suffering. And so the only way to open that door is to pass a statute that says you can recover pain and suffering for somebody doing something to you without touching you. And so that, you know, this is that kind of situation where, you know, that might be another different approach to look at this instead of focusing exclusively on the criminal sphere.
So we're talking about two criminal statutes that sound a lot alike but are different, indecent exposure and indecent liberties. The indecent liberty statute is the one that the Court of Appeals was dealing with in the Hillman opinion. And it's that analysis that I think would also apply to the indecent exposure statute that applies to adults. We've got a lot of behaviors that are addressed with both civil and criminal liability. Assault and battery is one, right? You can sue somebody for beating you up, and also they can be prosecuted for it. The problem, as Senator Surovell has mentioned, with the civil suit is you have to prove damages in some form. And that sort of takes us back to an earlier issue we were discussing: who assesses harm, right? So, you know, I think a criminal statute would be useful. A civil statute may also be useful.
I think that's great that you pointed that out, because a lot of the discussion has been around criminalizing the act, but that is a great concept to focus on the civil action, because that is an empowering mechanism for someone who has been offended or someone who has been violated. So I definitely agree with that. That's something that we need to visit and to make sure that that's probably something that's proposed as well. Do you have any other thoughts, Senator? I'm sorry, Senator, I promoted you, Delegate Fowler.
You know, I'd have to learn more about the civil aspect of it. My gut reaction was, okay, thinking through revenge porn, there's these consequences that happen after. I understand that civil, that would be a civil issue, but this issue, it really, if you take it and extend it from, if it happened to a child, and then you think about if it happens to an adult, I guess as a woman, I don't think a man's ever gonna understand how it feels, but it's very scary and it's intimidating and it's like a threat. And I'm not sure. I almost think we need to like analyze both sides of the civil and the criminal, and if we need to do both, but we also need to get the women to weigh in on it, right? We need to get all the information, because I don't know enough about it to even comment, but I feel like we need to get more and even maybe bring it here so that we can all kind of analyze what that would mean and look like.
Well, I think that's part of the uplift too, of coming together here on this panel to talk about, you know, kind of be in the wheelhouse there and talk about what we need to do, what we can do, what are some other avenues to protect people over the age of 18, because, you know, this, of course, we've been talking a lot about women, but it certainly applies to men as well. You know, they can be violated as well. We can't forget that. You know, we can't forget that people come to the table and have the ability to, you know, for their liberties to be impeded upon. So I was looking at some notes here, and it talks about 6 common types of digital abuse and harassment. And there's cyber stalking, which I've heard, you know, we know that one, doxing, online impersonation, concern trolling, flaming, outing, or then the one that we talked about also was the leaking of personal videos. So I think also just educating, you know, what do these mean? Like educating the public, but also people who are making decisions about how this legislation should go forward, helping them to understand what those things mean and how it can have an impact,
I think that's something that I would like to understand more, those categories and how this fits in with that, because I feel like there's a piece there. So it's really interesting.
Me too. I'm with you too. I'm thinking, I need to have another session so that we can go through those categories just by itself, some of the terminologies. So, well, I want to go into questions from the chat. So, do we have any questions, Jess, from the chat? Let's see what we have. And I think it may be that a lot of the questions we've kind of covered. One comment from one of our attendees is that when we talked about earlier, the young lady in the clip, and you spoke about how usually young men, because of their brains not being fully developed, might have a tendency to engage in this type of harassment. But Ms. Katina's harasser was not young. He was an older gentleman. And so I think we have to focus on those areas as well. What is causing, someone who has a mature brain, who should know better, what is that all about? Why does that person think it's a norm or that's okay to do? So one question is, what about criminals, let's see, for a pattern of behavior in civil for a one-time offense? Okay. I think we answered that. Did we not? Did anyone want to elaborate on that question a little bit more?
What's the question, Tanya?
The question is, one of the attendees mentioned that maybe having something criminal for a pattern of behavior and something civil for a one-time offense. I know we talked about that a little earlier and how maybe we need a little bit more education on maybe how the civil part would be implemented. Or
yeah, so Tanya, what I'd say is that having a pattern would definitely, I think, make it clear what's going on. I mean, we obviously use a pattern of behavior for stalking, right? Stalking typically requires more than one act after being told, I don't want to have anything to do with you. Right. And repeated behavior definitely sort of nails down exactly what the intent is. So, I think a lot of these concepts are things that are worth exploring.
We have that structure that I think your guest is suggesting with our refusal statute. First time somebody refuses to take a breath test after they've been arrested on suspicion of drunk driving, it's a civil offense. Subsequent offenses are criminal offenses. And that, I guess I'm thinking about drunk driving now because that's sort of an analog for me. When I was a teenager, I'm dating myself now, but when I was a teenager, it was largely acceptable to drive drunk, and it is no longer acceptable because we started prosecuting that. It wasn't civil liability that got us from there to here. It was the fact that it was a crime, you could go to jail for it. Right. And so I think of that as sort of an analog to this situation where in certain populations, this is viewed as acceptable behavior, and we're trying to put that in the other box, right?
Create a new norm, right?
Exactly right.
Another question, what would a woman need to do to prove that a photo was unsolicited and that it caused harm? That's a great question.
Yeah, and I'll tell you, that was one of the things we were sort of bubbling around with was, trying to prove it. I mean, obviously all you would have to do is testify it was unsolicited. But if the person had if they had a history in their relationship, it would get really complicated really fast as to whether or not it was unsolicited. And I know one of the edits that I offered to Kelly, or one of the drafts that she and I worked on after the bill had died, was the possibility of of it being an unsolicited picture sent between people who had no pre-existing relationship,
Mhm.
right? Because if you didn't know who this person was, you never met him before in your life,
Right.
you get a picture like that, it's pretty clear what's going on,
Mhm.
right?
Right. Yeah, that's a great point. Let me just check the chat here. We don't have any other questions that popped up in the chat, but we want to give individuals a moment. If you're thinking of a burning question that you want to send over to Jessica to submit, let us know. We'll give you a couple of seconds there to do that. But we want to really thank you again, because part of educating our community is having the conversation. I mean, that's the first step, is to have the conversation, to make people aware. Perhaps this has happened to you and you felt helpless, and you didn't know what to do, where to turn, or how to, feel whole again or empowered again. And so perhaps it is, reaching out to your senators and your delegate to say, hey, we are concerned about this. I'm concerned about this, and I want a change. So what can we do to work together to make this happen? I think this is an issue that, reaches across the aisles. It's not something that should be a partisan issue. And I didn't hear anyone say that anything partisan came up with regard to that. But I think that you have to, when it comes to humanity and treating people with decency, that's not partisan at all. So I want to thank you all again for coming, and I'd like to turn it over for closing remarks. Let me just check the chat one more time to make sure. There is one more question. Will the bill need to be fundamentally changed from last year for it to pass in 2022? That's a great question. Is it going to need to be fundamentally changed?
It may. We want to do whatever the intent behind it is for the unsolicited, inappropriate pictures to be against the law, right? Like that's just the basic, we all agree on that. So how we do it, this is what these conversations are for. That way we can get everybody bought in, since we're all in agreement that that's the intent. And then we all agree that we want to do that. We just need to figure out how to work it. I'm not an attorney as much as I wish I would have gone to law school. But so then I defer to the attorneys, and the comments I have heard today from Mr. Miles have been amazing. Like that feedback is I'm excited, like over here thinking about how we're going to get the wording right and figure out which section and the intent behind it. And getting Senator Surovell, thank you so much for being here too, because just having us in this conversation is getting all the buy-in and getting it perfect ahead of time, which is very valuable. So we thank you so much.
Absolutely. Well, I have one closing comment from one of our attendees, and we just want to, they're strong out here, these comments. But one attendee says that she doesn't want to have to respond to an unsolicited pic for it to be illegal for him to have sent it to her. And then someone else says, just wondering about how to establish the intent. Yeah.
I agree that you shouldn't have to send something saying don't do this anymore. But I will say that until we can get it on the books, you can respond to anything you get by putting a very official looking text back that says this is being monitored by, and we have detected an inappropriate picture violation of code. You could just make it up, and then you put that there and it scares them and they won't do it anymore. But until we get it passed.
Right.
I was looking at the Texas law, and I'm not suggesting that it be a model for what we do, but there is one feature of it that I think speaks to Katie's point. It requires that the picture is not sent at the request of or with the express consent of the recipient. So that puts it on the sender to get express consent rather than leaving it up, and we do it all the time. We leave it up to judges to determine by circumstance what is the intent. And that can go well or that can go badly. But this law makes it clear that it's up to the person sending a picture like this to get express consent or be responding to a specific request for the picture. And that seems to put the responsibility where it ought to go.
That sounds so, I think that's a great point, a great commentary there. So we want to have a few closing remarks from our Madam President. I want to thank you all again for being here at the table and for being concerned and for having the focus to make sure that we're coming to the table this go round and that we're able to make sure that this is going to be so solid that we're going to get something on the books. So I'm excited about our next steps. Madam President.
Well, thank you so much, Tanja, for doing an excellent job moderating tonight's forum. I really want to thank Mr. Miles, Delegate Fowler, Senator Surovell for your candid comments on this important issue. And just to reiterate what you said, Delegate Fowler, like this has been a very valuable conversation in getting us where we need to go. And I'd love to see maybe some briefings on the different types that we were discussing earlier, specifically for legislative staff and legislators. So we're really excited that we can play a part in and put, like Tanja said, putting something on the books. And, you know, I think it's really important that when we talk about legislation, I'm so glad, like I said, this was a very candid conversation because we talked a lot about the behavioral aspects, right? Like the things that are really happening in day-to-day life, and that impacts the legislation and how it can be implemented. So again, thank you all so much for attending this evening, and we look forward to seeing you at our next session. Jess, do you want to announce that one?
Sure. Bring us your voice and your friends' voices too is the title of our next session. It's on Thursday, September 30th at 6 o'clock. And we are inviting members and whomever they would like to bring as their guests to really go through all the sessions that we've had, review a little bit of what this conversation has had, and workshop this so that we can figure out something on how to join together and amplify our voices to make this part of the policy for 2022 in Virginia. And we really, really appreciate everybody's time and thoughts in helping us get together as members and work through this.
Thank you and have a great evening.
Thank you so much, everyone.
Take care.